Good evening, everybody. This is Jonathan Ginsberg. Hope you are all doing well, and hope that the weather wherever you are at is better than it was the last couple of weeks. It certainly is here where I'm at in Atlanta. It was about 72, 73 degrees today, which was a nice change from temperatures not getting above 30, which was what it was a couple of weeks ago. So we're going to go ahead and kind of jump right into it. Actually, I got a very interesting email from a gentleman named Thomas. I'm going to put that in the comments here. And it's, I'll just kind of summarize what he's saying is that he went to a general medicine exam with an internal medicine doctor, consultative evaluation. And he basically went to the appointment, gave him the paperwork. We'd gone to the emergency room for stomach issues over the weekend, along with other documents, as long as a 24-hour statement of what he does, and a summary of his medical history and so forth. And then in the middle of that, he had to go to the bathroom, and the doctor says, well, if you do that, I'm going to have you started over. I'm not sure if he meant you have to come back, and I'll suspend this. And basically, then he asked him to do some real simple stuff, walk around the room, touch his toes. It took about 7 minutes total. Then he left. And basically, this is a guy, it sounds like in a shopping center, renting a very small office. And so basically he sent it to Social Security. He wants to know if this is normal. And, this is one of these situations where, Social Security sends people out to these consultative evaluations. I had a doctor on who does this a few weeks ago. And, his explanation of how he does it's a lot different than what Thomas, the doctor that evaluated Thomas, did. John Foster, if you want to look that up in the previous live stream. My point is that a lot of the doctors that Social Security has on their panel to do these consultative evaluations get paid a flat fee. It's not very much money. They don't get paid extra to review records. They don't get paid extra to go over time. And so, to say they don't really care very much, maybe that's an oversimplification, but that's kind of the sense I get. A lot of these doctors are not the cream of the crop. And again, you can't say every one of them, but, a lot of them work for insurance companies that they do to try to get claims denied. So, unfortunately, what Thomas went through is not especially unusual. And what I would say to do is in a situation like that, like he did, write down exactly what happened so that if you get to a hearing, you'll be able to explain to the judge, this is what happened. And I would be able to make an argument that this consultative evaluation, whatever the results are, whatever the conclusions are, should not be given very much weight because it was really kind of a bogus examination. But, is it normal? Unfortunately, probably more normal than it ought to be. Does that mean that it's going to sink your case? No, I think most judges kind of know that these are a bunch of kind of BS. So that's what I'm thinking about that. But I appreciate, Thomas, you writing in and giving me something to talk about at the beginning, because I think it's a very good point. A lot of people have concerns about consultative evaluations. And I'll say again, my experience has been that the physical medicine consultatives are often pretty useless. The mental health ones, the psychologists, are often a lot better because these are practicing psychologists who actually, see people on a regular basis and do this to supplement their income, but they typically take it a little more seriously than some of these, insurance company doctors that do it in a rented office in a strip mall someplace. That's just my take. Okay, let's jump in. We have Sandy Midnight Mueller saying, hello, Sandy, how are you doing? Tara Denise says, hi, waves to me at hi. Eric, who's one of my clients, and I appreciate that, Eric. We have a hearing coming up, as you know, in a couple of weeks. I am almost done with the brief. I'll send it to you in a couple of days, or maybe hopefully tomorrow even, and we can kind of use that as a starting point for our pre-hearing discussion. I do briefs in almost every single case, and it really kind of summarizes what's going on. It gets me kind of really into the case, and also it avoids the need for me to give an opening statement. And it may sound a little strange, but hearings nowadays are about 45 minutes. And it used to be, judges would schedule every hour and a half, and you could take an hour and 15 minutes. Now they want to do them in 45 minutes. So, for me to take 7 to 9 minutes to do an opening statement is a big chunk of the hearing, and I'd rather you have that time to talk. So I do my opening and my theory of the case in a brief format where I do a written pre-hearing brief. I think judges like it because it really sets up the theory of my case, and I can say what I need to say in as much time as I need to say it. And usually it's 2, 3, maybe 4 pages, but I think that's a more efficient way of doing it. And that way, when we get to the hearing, we get right to the gist of it. That's what it's your hearing. It shouldn't be me talking. It should be you talking. But Eric, you'll have my brief in your hands in a couple of days at the latest. Okay, Laura. I'm at my initial application. DDS asked for me my contact person for an adult function report. Does this mean if they decide does this mean they're about to decide if I need a listing or not? No. I think that realize that Social Security, first of all, defines disability in terms of how your medical issues prevent you from working or doing what is called substantial gainful activity. And that is defined as, doing something that would earn you $1,620 a month gross, or volunteer work that is roughly equivalent to a job that would earn you $1,620, something along those lines. So that's the definition of disability. The adult function report is a way for Social Security to sort of understand what you do on a day-to-day basis. There are 3 ways to win a disability case. One is to meet a listing. There is a function element to every listing. Again, go to meetalisting.com and you can look at the listings. But even the most serious medical problems, it'll say the diagnosis is X and results in, XYZ loss of function, inability to, complete activities of daily living, inability to maintain attention and concentration. So it is a part of that. But generally speaking, there are about a third of the applications are approved at initial, but a lot of those are people with, situations or conditions that are life limiting or life threatening. And so they get approved early. And as we talked about last week with this new emergency message, we'll probably see more of those. More cases are decided on the functional capacity argument, which is typically going to go to a hearing. And that's where a judge is going to look at the medical evidence, look at and listen to your report about how your functions have been minimized or limited by your medical condition, the forms you filled out, and you want to make sure they're consistent. And the real question is, are the functional issues you've identified consistent with what the medical evidence shows? And so this is part of that. So I would look at this more as Laura, as a way for Social Security to get an initial idea of the functional limitations you have. The adjudicators will also look at that to see what type of consultative we need to order. Usually it'll be an internal medicine consultative, but it could be a psychological consultative. I've had people, tell me that they didn't reference any kind of depression or anxiety in their application, but when they're filling out their adult function report, it talked about those things. And so, the adjudicator said, well, there may be a mental health component here, ordered a consultative evaluation. So you want to fill that out as completely as you possibly can, with special emphasis on being specific. Avoid things like not very much or not too far, just a little. You want to be 10 minutes, 30 feet, 15 pounds, something like that. I was doing a pre-hearing call with a client today. We've got a hearing next week, and she kind of I wasn't upset with her. She just kind of went into that normal conversation of it hurts me when I do the laundry. I can't do it for very long. Well, how long is too long? Is it 10 minutes? Is it 3 hours? And so we practiced, let's talk about 15 minutes, 10, 15 minutes standing, and then you're going to take a 10 to 15 minute break. And I told her, I said, that during the hearing, if you kind of, resort or go back to that very generalized, not very long, not too far, I'm going to stop you and I'm going to say, let's kind of I'm going to pin you down on that. What does that mean? Not trying to be rude to you or make you uncomfortable, but that's what the judge needs to know. So when you fill out this report, Laura, anybody else filling out an adult function report, you want to be as specific as you can when discussing limitations that you've got, whether it's sitting, standing, lifting, kneeling, crawling, crouching, or if it's mental health, focus, attention, concentration, pace of work, emotional stability. You want to be specific, and if you can give, feet or yards or miles or pounds that you're able to lift or time that you can walk or stand or whatever it may be. You want to be as specific as you possibly can. But bottom line is, to answer Laura's question, having an adult function report is a small piece of the puzzle, but it does not mean that they're going to approve you on the listing. It could mean that would be something that might go into a listing analysis, but more likely than not, it's part of a functional capacity evaluation, which is by far the most common way disability cases are approved. Main event says, good evening. I appreciate your insight. Well, my pleasure. Thank you very much, Main Event. I appreciate you coming every week. Okay, Blue City Garage says, I have an internal CE tomorrow. I'm taking my nerve conduction test, your EMG, MRI, CT reports. It's been 18 months since you filed, 60 years old. What should I do if denied? I'm prepared to call you. Well, great. That would be awesome if you did. And is an internal CE different than a CE medical? No, it's basically a physical medicine consultative. I mean, every once in a while, you see a situation where Social Security will send you out to a specialist, like a cardiologist, a pulmonologist, something like that, or, nephrologist. But generally, it's going to be an internist, a family medicine doctor. As I talked about at the beginning, a lot of these doctors are industrial clinic type of doctors that do work for insurance companies to deny claims. So they're not going to be really on your side. A lot of them, this is what they do to make a little bit extra money. You're not getting, the Johns Hopkins trained, physician board certified. These are not typically, the most highly trained doctors. Not to say that there aren't some good ones, and I've seen some very good CE doctors. And again, John Foster and his description of what he does, appears to be, and when I've seen his work, a lot more high level than what you see a lot of. But a lot of it is just, just very run of the mill type of stuff. But that's what it's going to be. And in a way, I would just tell you, go there, cooperate as much as you can, but don't overthink it. Don't worry about it too much. Just tell your story, tell the truth. The main thing you want to do is you want that doctor to see that you're believable and credible. Don't say that everything hurts 24/7 at a level 10 on a 10-point scale. You want at the minimum the doctor to say that you appear to be a reliable historian and that you're not exaggerating your claims. And he may come back with something that is, not that you're not disabled, but at least he's not saying you're malingering or have secondary gain or drug seeking, something like that. So in many cases, that's the best you can hope for with some of these internal medicine CEs. So, again, assuming you've got your own doctors that have, said something in your behalf or will support you, that's going to carry a lot more weight than these consultative doctors. I hate to rag on them because I realize not every one of them is terrible, but I will tell you, after doing this for 35 years, generally speaking, I don't put a lot of attention into what the consultative doctor says. And if it helps me, obviously I'll focus a little bit more. But I mean, literally, when I'm doing a brief, I may reference it and just say that it seems inconsistent with the bulk of the evidence from my clients' longtime treating physicians, and it should be given minimal weight. Or that the consultative doctor did not have access to, MRI tests or EMG tests that really would have, made a difference in his or her analysis. So I just don't worry about him too much, because I don't think that, look, if a judge wants to deny you on the basis of a consultative evaluation, judge is going to deny you, nothing you can do about it. But I think most reasonable judges kind of know this is just something that they have to do. Social Security does it, and it doesn't mean a whole heck of a lot. Lily says, my long-term disability claim adjuster asked my long-term disability attorney about MMI, or maximum medical improvement, but I'm not on workers' comp. Can a doctor's statement that I'm an MMI help or hurt my SSDI application? Well, first of all, let's understand what MMI means. And it is generally used in a workers' comp scenario. Maximum medical improvement, meaning that, there's as much that can be done has been done. There's really nothing else, generally speaking, that can be done to make you better, to improve your situation. And in the workers' comp context, they will typically assign a disability rating, a percentage. It may be, 20% disabled to the right upper extremity, which translates to 10% disability to the body as a whole. And, that doesn't translate specifically to the Social Security disability world, but I think that if the doctor says you're MMI, maximum medical improvement, and here are the limitations you've got in terms of functioning, and those limitations, would allow you to return to, if you're under 50, for example, a sedentary job, or if you're between 50 and 54, to allow you to return to, a light job, something like that, then it could hurt you. Generally speaking, insurance companies don't ask doctors for conclusions about things because they think it's going to help you as the claimant. They want to do it to minimize what they have to come up with. And obviously, in a long-term disability context, they want to limit what they have to pay out. And so perhaps, there will be perhaps the long-term disability definition of disability might be own occupation for a year or 2 years, and then it turns to any occupation. And so if the doctor says that you can't do your past work, but you could do something else, like put ink pens in a box, then the long-term disability says, well, we're not going to pay you anymore. You're no longer disabled under our rules. And of course, Social Security uses that any type of work at all, if you're under age 50. So you have two systems, the long-term disability system, and you have the Social Security system with slightly different definitions. It's not the same. One is not going to control or obligate the other. But evidence that indicates you have capacity that is, especially if you don't really have that capacity, is something that will not be helpful. And again, you've got to submit all of the medical evidence in your Social Security case. So I would say generally, getting statements from doctors that insurance companies want is, probably not a positive, but you can work around it in the disability world, because again, it's different standards, different definitions, and what's binding on one is not binding on the other. I mean, VA is another example of that. VA has a very different standard for disability, not binding on Social Security at all. And I've had people that are 70% VA disabled but win Social Security disability. On the other hand, I've had people 100% VA disabled who don't win Social Security. So different definitions, different motivations. We'll put it that way. Okay. Let's see here. Let's see if I've got this correct here. Oh, that was the statement I'd gotten from Thomas there. Okay. We have a greetings from Koril Katana. Korlil, greetings. How are you doing? Robert Long. Very, very good, Robert. That's a great question. No one's ever asked that question before. That's an excellent question. If an SSD applicant loses their case, are they liable for court costs similar to other civil court cases? Freezing rain here in central Pennsylvania. No. To my knowledge, there is no attorney fee sharing or attorney fee turnabout in a Social Security disability case. So if you lose at the ALJ level, you go to the appeals council, you lose there, you go to federal court, and the federal court declines your case, you're not going to be liable for attorney's fees. I suppose if there was some fraud, there might be, in a very unusual situation. I've never heard of that. But no, there's no attorney fee issue if you go to federal court and you lose. In fact, there are provisions where in federal court you can add, there's something called equal access to justice fees that can be paid. And I don't know 100% I want to say this for certain. I know you can get EJA fees if you win. You might be able to get them if you lose. The attorney can. So I'm going to have to ask. We've got a federal litigator coming on in a couple of weeks. We're going to ask her about that. But no, there would not be any reversal of attorney's fees if you lose in federal court. But great question, Robert. And I'm sorry to hear about the freezing rain. I know that it's been pretty nasty up there. I have a good friend of mine, one of my tennis buddies, is from the Philly area, and his mother, who's I guess in her 80s, slipped on some black ice and fractured her ankle and broke her foot, in 3 or 4 places. And so he had to fly up there, and he's like, I saw him last week. He came back and he's like, because you go up there, it's just this miserably gray, rainy, cloudy environment where it's freezing cold, 35 degrees and just miserable. And, he lives in Atlanta now. And even though last week in Atlanta was probably, 63, 65, but, it was much more comfortable than Philly. So it's one place I've never been. I've never been to Philadelphia. One time I was supposed to go with our family trip and I hurt my back. I just threw it out. I was actually taking the suitcase upstairs, twisted my back, and I couldn't go. My family went, my wife and kids went, and I just stayed at home. And I just kind of rested, but I've never been there. Someplace I would definitely like to go because I was a history major, so I know there's a lot of history there. So I would love to get to Philly, but it is not in the wintertime. Let's put it that way. Okay, Terry Core, why are SSDI appeals taking so long at the Appeals Council? It's just a function of there are just not enough people. I mean, Congress has starved Social Security for funding for years, and the money they do allocate has generally been to fund continuing disability reviews. It's just not a priority. So the Appeals Council does not have enough people. When people leave, especially the staff people, it's really hard to get allocations to replace them. I know right now there's a hiring freeze. There's been a lot of discussion on the listserv that I participate in about, people that maybe shouldn't have access to the federal checkbook, not writing checks. Now, I have not seen that so far. The checks that I'm supposed to be getting for the cases I've won are coming in. But, there's a lot of concern that, one of the ways that, the folks that want to really cut some of the federal budget are going to try to starve, whether it's the attorneys or the disability claimants, but making it take longer. I mean, I hadn't seen it yet, but we're watching that really closely. But the answer to your question is, why is the Appeals Council and all these, steps, even, initial recon, all that stuff, hearing, why is it taking so long? It's just they don't have enough people. The one place right now where they do have enough is at the hearing stage, because they have, even though there's a lot fewer judges, there are not as many cases at the hearing level right now. So usually when I request a hearing, I get it in about 5 or 6 months. Now, right now at the initial and recon, there's over 1 million cases backlogged. And as those cases make their way through the system, in a year and a half, we're going to start to see a real problem at the hearing stage, because there won't be enough judges to hear these cases. And if they keep hiring freeze on, then there won't be any more judges coming online. So, and it takes a while to get judges trained. It takes a while to get hearing staff, office staff trained. So, we're watching that. It could be a very, very difficult road to go in a year or two. So I just sort of take it one day at a time, and I look for good cases. I go ahead and get them developed as quickly as I can, and make it as easy as possible for Social Security to approve them. And just by the way, sometimes I hear this, and I've talked about this before, but I'll just say it again. Attorneys in this area, there's people who say, well, the attorney has a built-in incentive to delay the case. They'll make more money, but if it goes to a hearing. Let me promise you, given the long delays, the unpredictability of judges, and the uncertainty of who's going to get paid when, the last thing anybody would do would be to purposely delay a case. If I can get a case approved early, I am thrilled to do that. I'm going to, even I've had cases, my fee is $600, $800, $1,000, whereas if it goes to a hearing and it takes 3 years, it could be $7,000, $8,000, $9,000. I don't care. I want that case approved, because you never know what's going to happen the longer you wait. And, I've had really good cases, and all of a sudden I look at the judge, and it's a judge who pays 15% of the cases, even if it's the best case. So you never want to roll that dice. If you can win early, you win early. Because it's a smart business decision, but even more so, there's an ethical obligation we have as attorneys to do what's best for our client, regardless of fees. And that's why when if I have a situation where a judge changes the onset date and it means no fee for me, but it's beneficial to my client, go for it. Write me a nice review. To some extent, it's a numbers game. There's plenty of business out there. and you got to do what's right for your clients. So anybody who says attorneys are deliberately delaying, nobody I know, and I don't think it makes any sense at all to do that. It's just for many reasons it's not going to happen. Okay. Corlil says, as a client, would you have the ability to review an ME, a medical consultative doctor's report? Absolutely. In fact, when I get on a case, I will have access to the electronic folder, usually within 3 to 6 weeks. And then as soon as that report comes in, usually in a couple of days, I can download it, send it to my client. I have electronic access to all of the medical records as soon as they come in. I can also upload directly to the Social Security file. But yes, if you have an attorney, whether it's me or anybody else, and they have electronic access, assuming that you get it pretty quickly, you can get that medical report right away. And I usually will, people want to get them, I'll send it to them, or I'll send them the whole file. I'll just download the whole thing as what they've got as a PDF. Here it is. Because, you need to see what's going on. And I also, encourage my clients, even after the hearing, let me send you the PDF of the entire folder, file, everything in it, everything I had. And that way you've got your own, medical file and case file, so that if down the road you need to reference it, it's there. Of course, I keep that kind of on a permanent basis anyway, the PDF, but you should have it too. So, but yes, you can get access as soon as I have electronic access, I could get access to it. Muley says, I waited on the phone with SSDI for 3 hours. Nobody answered. This is unacceptable. I know that they're lacking people at 3 hours and no answers. What do you do? This is exactly the problem. They don't have enough people, and that 800 number is it's ridiculous. And, I know that, when Commissioner O'Malley, the previous commissioner who's now gone, I remember he was at a meeting or something. I think I'm not sure. I'm not sure if I'm 100% correct in this, but I think he picked up the phone in a meeting and called the 800 number and just it went on hold, and he just sat there with his staff, and they were getting more and more uncomfortable because it was taking, 45 minutes before somebody picked up. But 3 hours, yeah, it's crazy. I think in this situation, you might have to reach out to your U.S. Senator's office. You might have to, contact the head of the office that you're trying to call. We do a lot of faxing or uploading messaging. You can get the fax number if you go to the ssa.gov/locator. You can get sometimes the direct office to the local office or the fax number. We typically, what we do in my office is if we need to get information to an adjudicator, we'll draft a letter, we'll upload it to the client's file, and that way we know they've got it. But yeah, I mean, when you call, it's a crapshoot. Sometimes they pick up right away. Sometimes, you just wait. I almost never call the 800 number, by the way. The 800 number, to me, the 1-800-772-1213, waste of time. It has been for a long time. That's what you're calling. So what I would do is I'd look at the ssa.gov/locator, put your zip code in, and then, try to get a more local number. And that may be better, although now a lot of them, when you put in your zip code and you ask for a local number, it gives you the 800 number, the 1213. So it's a real problem, and they don't have enough people, and there's no solution to it, unfortunately. Jeff Brown says, good evening, everybody. Good evening, Jeff. I hope you're doing well. And Corlil Katana, thank you very much. I appreciate that. I think I mentioned we try to do lunch in the office periodically, and this goes to that fund. Or I'll take my son who does my video editing. I'll buy him lunch at a deli or something, and that's what this goes to. So I'm not a coffee drinker, but it'll go to a sandwich or maybe a chocolate chip cookie, which I am. I do indulge in a dark chocolate, that kind of stuff. But I really appreciate that. Thank you very much. Ms. Crystal, if you're approved at the hearing level, the appeals council is overlooking or taking another look. What does that mean? Again, very good question. And Crystal, I know you come most weeks here. What she's getting at is that in some situations, you'll get an approval, and then you'll get a notice a couple of days later that the case is being reviewed by the appeals council, just to almost as a quality control type of thing. And in theory, the appeals council could say that the judge made a mistake, or that the adjudicator made a mistake and reverse it. I think I can't remember the last time I had a situation reversed. I think maybe once or twice in 30 plus years. Now, doesn't mean it couldn't happen more in the future. No, I had this happen actually in a case last year, and my client, good guy, really interesting guy, and he had actually rescued a dog, and it was really a very interesting case. Rather it had nothing to do with his case, but he'd been on the national news for rescuing a dog, and he was just a really interesting character, interesting guy. And we had some really nice conversations, but his was a case where we won at the hearing, and then lo and behold, we get a notice the case is being reviewed by the appeals council, waited about 2 weeks, and then they said, go ahead and pay it, and everything went through as it did. So I don't expect there would be a problem, but you never know, but I don't think there'd be a problem. Giselle Murray says, I'm currently working, want to apply for disability, have not afforded working. Let me try that again. I'm currently working, says Giselle, sorry. Let's start again. Giselle says, I'm currently working and I want to apply for disability. However, I cannot afford to stop working full-time. What can I do? I wish I had a good answer for you. The only thing I can tell you is, A, if you're working below SGA level, substantial gainful activity, which is $1,620 gross, you can work and still apply for disability. Obviously, what's that, $19,000 a year, not a whole lot of money. That's not going to fly. Otherwise, in theory, you could work and then argue, you can have what they call 9 months of what they call trial work period months. So theoretically, you could use your trial work period months right after you apply. Some judges will go for that. Others are going to say, we'll start the disability when you stop working. The real answer is, as long as you're working, it's going to be really hard to apply for disability. And there is no answer as to how you eat, how you provide shelter for yourself if you're waiting 2 years for a disability hearing. I have no good answer for you. This is just the problem with this program is it takes too long, and you have people that really need to be pursuing disability. It's not healthy for them to risk their whether it's their back or organs or whatever it may be, their mental health, but they've got to work to pay the bills. There is no good answer to that. So I would just tell you, work as long as you can, and if you get to the point where you can't, maybe the time now would be to save up so that you have some money saved, so that during the 2-year wait, if you need to file for disability, you have money. Talk to friends and relatives, see if you can get some support that direction, so that you're not completely left holding the bag. But no good answer, Giselle. I wish I had a better one for you. Violetta, hello, Violetta. So she says hi. Now we have Jenny Joe, one of my clients. Good evening. How are you doing, Jenny? Muley says, what is the average time frame for the initial decision? How many months for initial decision? In general, I'm seeing initials anywhere from 8 to 15 months. 15 months on the outset. Some states like Texas and Florida, it could be 15 months plus, but most states it's 8 to 12 months or so. But I think that time frame is getting longer because they have more cases and fewer staff. So I'm going to tell you, 8 to 12 months on average. And I do think this is an area where being a squeaky wheel can help you. If it's been more than 5 or 6 months, I would say reach out to your U.S. senator, U.S. representative, not your local, city council person, but somebody who's a federal representative, and say, this is causing a lot of financial hardship. Will you make a call? Will you do a congressional inquiry? That may speed it up a little bit. But that's on average for me, at least, what I'm seeing. Trish Wade, good evening. Good evening, Trish. She is here many, many weeks, which I appreciate. Violetta says, if I have a hearing with the judge because of illness and medicine, I cannot come to the court. The new law is passed, you can talk on the phone from another country. Most hearings now are done by phone or video. So you can request, and I would tell you, if you are in another country, you can't do it live, make sure they know as early as possible that you want a virtual hearing, a telephone hearing or a video hearing. Every time you send something in, please reiterate, I'm requesting a telephone hearing. I'm not physically able to come to a hearing. It's now the default. Now, there has been, again, some discussion because under the new administration, Trump administration wants federal employees to come back to work. The Social Security judges in particular have a contract that was entered into with the union that says, the judges union says they can work remotely. So there's going to be a standoff. I don't know what's going to happen there. And whether judges are going to say, if we're coming back to work, we want all hearings done in person. I don't know. I mean, the sense I get is that most judges are not going to do that. I think you'd have a lot of really unhappy attorneys because everybody that does this now takes cases from all over. I will tell you on the listserv, every day there are people saying, an attorney in Michigan says, I need to know about this judge in South Carolina, and somebody will say, well, he or she is this or that, and this is how they conduct their hearing. So we're all doing cases remotely. So I think it would be a real problem if they start demanding in-person hearings. I think a lot of people would stop doing it because it's just not really practical. So we'll see. Excuse me. Pardon me. But in any case, I think that, if you want a virtual hearing, what you need to do is make that fact known as early and as often as you possibly can. And Violetta has a lawyer, so make sure your lawyer will do what to do. There is a form called the NOSCR form, the National Organization of Social Security Claimants Representatives. There is a form they put out that I use, and you can have your lawyer send that in. That would be certainly helpful. Giselle, what are the disability changes to the new government policies? At this point, nothing definitive. The one thing we do know that did come down was that emergency message, which is really going to, I think, help us. It gives adjudicators in some circumstances the right to approve a case without going through medical review. This is designed to get rid of some of the backlog and give experienced adjudicators kind of the leeway to approve cases. But beyond that, there has been no substantive indication about any substantive changes from the new administration, what it means. So we'll keep an eye on that. But right now, nothing yet. Rick Torres bought a super sticker for $5. Thank you, Rick. I really appreciate that. It's always I'm always grateful. Again, this will go to my son. Will be happy because he'll get a sandwich out of it, and I may get a chocolate chip cookie out of it. So all good. But I really appreciate that. Kay Patrick, 56 years old. That's helpful. Peripheral neuropathy in the hands, carpal tunnel, cervical fusion. Hearing in December. ALJ did not ask my attorney or me any questions. Only one question for V with the 12% off task. All right. Well, 12% off task. It kind of depends on the VEs in your area because some VEs will say 10% off task. Anything over that is excessive. Others say 15%. That's actually an issue I've never really gotten an answer to, is that why are some VEs 15%, why are some 10%? But if the judge asks no questions and the VEs in your area are using the 10% standard, then you've likely won. 56 years old, peripheral neuropathy, carpal tunnel, cervical fusion. I'm guessing you have a pretty good grid rule argument as well because, even if you could do light work, which is lifting up to 20 pounds, I suspect you can't do that. And if you've got pain and medication side effects, that's going to make it hard to focus and concentrate and transfer any skills. So, I'm cautiously optimistic that this is all a positive, that you would win. Now, the only caveat would be if the VEs in your area use that 15% off task standard, obviously the judge knows what they use. And if that's what they do, then that's not a good sign. But and that's what, the question I would ask your attorney is the 12% where we are, or this hearing is at, is that enough to win? Or does that mean the judge is trying to, basically say you're almost disabled, but not quite? And of course, did your lawyer ask questions as well, I'm sure. But I'm cautiously optimistic for you that you'll get approved. This is how you get, actually, I need to put that up. I forgot to do that before. Yeah, if you want a free case evaluation, that is where you would do it. So please, please let me know. I'm happy to we get a bunch of emails every day from people asking for case evals, and I'm happy to do them. K. Patrick is still awaiting a decision. That's the person, the 56-year-old. So again, that's my opinion. It may be you're in really good shape, or depending on the VEs, it could be not so great. But hopefully it's a good news. You're very welcome, Yuli. I'm happy to answer questions from you anytime. Do you think, Angie says or asks, they're going to lay off Social Security employees or other 3 agencies that have been in the news? I think that Social Security employees are getting those letters offering a buyout. In fact, I was looking at Charles Hall's blog, and he even put a poll up, and he put as a copy of the deferred resignation letter, where, they're offering Social Security employees a buyout to resign early. So we're going to see, now again, according to the poll, many of them are not going to take it, but I think that one of the things they're trying to do is to cut the workforce. And, I don't know how much more they can cut. There's not enough people as it is. So I'm not sure what's going to happen. It's going to be really interesting. It's going to be really interesting. But certainly fewer people is not a good thing. And the result can be wrong and biased. And this is Giselle, talking about, she was asking about some of the changes and things like that. She was the one who was working full time, and obviously it's not real happy about it. That basically what I said was, if you're working full time and you can't afford to stop working to wait for disability, then you're really kind of between a rock and a hard place. I agree, it's not fair, but that's just the way it is. The system is really broken, and I kind of get the sense it's not going to get a whole lot better anytime soon. Apostles' Creed. I have a multi-level cervical discectomy infusion. I've been denied twice, but I have a phone hearing next week. My 2 doctors filled out paperwork, said you cannot work, you're 33. So everything looks great except that you're 33. So, my sense is that, judges that approve less than 40%, and again, I think you need to look and see what your judge does. But judges that approve, less than 40, less than 45%, the cases they do approve are typically people over age 50. So being 33, you got to have a really, really high level of, or a lot of quality and quantity of medical records. And there are certain people, in their 30s who have enough. And I hope that you're one of them. But that is going to be the big hurdle to get over. When I'm looking at a case, I take cases from people in their 30s sometimes. It's got to be a, 3 times as strong as that same case would be if the person was 55 or 57. It just is. So I hope that it was one of those cases where the evidence is so strong that even though you're young, let them put you on a 1-year review or 2-year review. But, if you really can't work, you got support from your doctors, you've got objective evidence that is consistent with your complaints, hopefully you win. Tara, good to see you here, Tara. Thank you very much. I know you're here every week, and I appreciate that. So Apostle, I can't give you a percentage. I just think that, I would look at the judge's approval rate, and hopefully, and you have an attorney, which means you had an attorney felt that your case was strong enough to win. So I think that's a positive as well. So, I think that you've got a lot going on here. It's objective evidence, significant impairment. I suspect that, there's a pretty strong argument to explain why you would not be very reliable, and I hope that carries the day for you. Sarah D. I have chronic long-term anemia that impacts blood oxygen levels, require iron infusions every 3 months, lose all your ferritin, lowered hemoglobin. I have chronic diabetes that uncontrolled blood sugar along with chronic anemia. And the only way to correct my anemia is major surgery, hysterectomy. I have to wait until I have better blood sugar control. Not sure. Oh, let's see what we've got here. How likely, and you don't say, Sarah, how old you are. That's one question. So I would say, again, let's set the age issue aside. Maybe you'll tell me in a second here. I think that these conditions obviously are ones that would negatively impact your capacity for work. Low blood, not having blood sugar control can make you very tired. It can make you unable to concentrate and focus. Anemia obviously can do that. Diabetes, out of control, many other complications. You're thirsty all the time, restroom issues, things like that. Depressive disorder, anxiety disorder, all these type of things put together, I think would make it really hard for you to be a reliable employee. So if the medical evidence is there and it supports all this, then I think you've got there's objective evidence here. This is not, I'm depressed and anxious. You've got, blood oxygen levels that are too low. Those are the sort of things that move the meter in Social Security. Now, if you're over 50, better. If you're over 55, even better. If you're 35, again, you're going to have a lot of evidence, even with all this, to convince a judge that this is not something that you can work past. So overall, good case if you're over 50, especially. And I know, with diabetes is one of these cases where, when you have chronic uncontrolled diabetes for a long period of time, and a long period of time, I mean 2-3 years, it can start to affect your organs. It can affect your vision. You get peripheral neuropathy, numbness in the hands and the feet. That's not reversible. So, I think that's also a factor. How long has it been out of control? And have you made diligent effort to get it under control during those times? Okay, in Apostles' Creed, we'll go back to him for a second. Injury happened on the job. So there's a workers' comp element. I just want to reference that if you're still getting workers' comp, that's going to offset your Social Security. That is a whole nother issue there. But just if you've got an attorney for the Social Security, make sure that he or she knows you have a comp case as well. You've been approved for New York City disability retirement, which, again, may be an offset. So just be aware of that. Let's see. I was approved, Ali Tovar. I was approved for my SSI. Can I tell them my sister is claiming my kids and I received money for my bills for my friend that is considered income? I don't understand your question. If you're approved, I don't know. I honestly don't really understand what you're asking me. I'm sorry. Maybe you can rephrase that because I don't know what you mean. Can pulmonary embolism qualify for SSD? Pulmonary embolism, your blood clot in your lungs. It just depends. It depends on what the effect of it is. How long have you had it? Is it something that can be treated? What does it mean? Are you chronically short of breath? Are you, there's just a lot of things, because really this Social Security is very practical in the sense that what they want to know is how your medical condition affects you in a work environment. I'm working on a case right now where my client has chronic, blood clotting issues. It's a congenital issue, and he's got pulmonary embolisms, and he's got DVTs in his leg, and he's got all kind of things, that just continuously happen, and ongoing. He's younger actually, and ongoing, blood clotting issues. If you have to keep your legs extended, over waist level the majority of the day, that's not consistent with competitive work. Employers aren't going to let you work with your legs extended. So I think it's just, what does it mean? What is the narrative here? What does it mean that you've got a pulmonary embolism? How does it affect you? And has it lasted or is expected to last 12 consecutive months, which is part of the definition of disability? No Sky says hello, and hello, No Sky. Loki and Pearl are joining. Well, you've got Loki and Pearl appear to be dogs. So hello, Loki and Pearl. And I assume it's their human is joining from Southwest Florida. Good to see you here. And No Sky points out that subscribe to the stream and you'll be notified every time I go live. That is very true. Thank you. Where's Christina, by the way? She's always here to tell people to do that. Hopefully she'll join in a few minutes. Harold says, my adjudicator wants me to give him a call, but he'll never answer his phone. Been trying for a month and a half. Is there a supervisor? Yeah, there is a supervisor. What I would probably do is I would write a letter. And again, if you go to ssa.gov/locator, you can get the address where to send it. If you've got a case number, reference that and write a letter and say, I've been trying to call, multiple times. If you can give the dates and times, please call me at such and such here are 3 dates and times I'm available. Call me on one of these. But I've been trying to call you. That goes in the file. You might also contact your U.S. Senator representative. He's asked me to call him. I'm trying to call him. He's not picking up. So if they try to come back and say, I didn't cooperate, no, here's the paper trail that I've tried to cooperate. So that's what I would do. Justin says, I just sent hearing paperwork back to SSA. How long does it wait to your hearing date? If you requested a hearing, you should get a hearing date 3-4 months, typically. That's what I'm getting. How much too much income for the non-medical review for SSI? SSI has a, if you just type in income limits for SSI, it's like $1,000, not very much, but you just go to Google and type in income limits for SSI and it will tell you exactly what it is. So that's where you'd find that out. All right, Sarah is the person. Okay, so we already talked to her, talked about her situation. GC24, treatments and evidence is king. Make sure your treating doctors write notes, any symptoms you spoke about. True, and I would go beyond that. I'd say not just symptoms, but specific limitations on activity. So it's not just you're complaining of, of pain when you're walking, but walking more than 10 minutes is a problem. So try to make it quantifiable as much as possible. Not just symptoms, but quantified limitations, measured limitations is what I mean in symptoms. KP says, do you need to wait more than a few months after your employment ends before applying? No, you can apply the day after you stop working, as long as there's a reasonable expectation that you are not going back to work. You don't think you'll be going back to work. And if you do, you can always either wait and see what happens if you're successful, or you can cancel your application. You could even theoretically apply before you've left work if your work has been reduced to a part-time under SGA amount, or you're getting special help from your coworkers. But generally speaking, those people wait till they stop working. But if you stop working on February 5th, then file and say my onset is February 6th, right away. No reason to wait. Don't think they're going to call you back before the end of shift. That is not true. Okay, Mr. This might be valuable. Okay, so I think, Thomas, if you look at the first part of this, I answered your question because I got your email and I didn't answer your question at the beginning. And so I would refer you to that. But the answer, quick answer is that what you went through is unfortunately normal, relatively normal, but it's not right. And I think that most judges would not give that decision or that evaluation a whole lot of weight. But I did answer that. Let's see. Okay, I'm nervous for my non-medical reviews. We're going to suppose some kind of income. You deny what's worse. Don't want my friend sends me money for total of gift. I think, so what Allie's getting at is, there's an income limit for SSI and she's getting support from her friends. Simple thing to do is create a contract where you agree to pay it back. Just make it a loan. So any money you get, call it a loan. And again, you've got to make a decision whether you want to obligate yourself in writing to paying money back, but you show that to Social Security, I'm borrowing money, and the agreement is I will pay this back at some point in the future. And, just a simple contract, go to the office supply store, go online, get a simple loan contract, and show it to Social Security. That's the way I would get past that. Okay, so $550. Again, I don't want to go into I don't deal with a lot of income and resource issues in SSI, so I would do one of two things. I would look up income limits for SSI, or you might want to reach out to Greg Brinkley, Greg at gregbrinkley.org, I believe, or just look up Greg Brinkley, Social Security, and he can probably answer that question for you better than me. JMAC, not able to sustain focus on work-related tasks on a consistent basis, PTSD, major depression, pre-severe degenerative PE, I'm not sure what that means, severe degenerative disc disease with spondylosis of normal range of motion, 48. I think that medical issues like degenerative disc disease, which is spondylosis, same thing. Abnormal range of motion. If it's physical and there's a disc issue, that's going to be a stronger argument than PTSD and major depression generally. I find that with mental health cases, unless I have things like suicide attempts, inpatient hospitalizations, multiple failed medication trials, the default for Social Security is to assume it's kind of a mild problem as opposed to something that is truly debilitating. So, and you're 48. So, again, it's a matter of degree. If these conditions are really serious, there's a lot of really strong medical support, that's great. But, 48, you run up against the fact that, the most common problem people talk about when they apply for disability is back pain. Second most problem is depression and anxiety. So, they make it really hard to win on those two conditions, which are your two conditions. So you've got to have a really severe level. If you're over 50, then you got the grid rules you can turn to. At 48, it's better than being 43 or 41, but it's going to be more of an uphill battle. So you're going to really need strong support from your doctor is what I would say. GC says, I learned from experience diagnosis doesn't mean anything about your RFC, whereas evidence and treatments to get you to sedentary or less. RFC stands for residual functional capacity. GC is right. It is about the diagnosis is not going to carry the day. It's going to be about your functioning. And the residual functional capacity, that is a legal term that basically means what is your capacity that's left over, that's residual after you factor in all your medical problems. So a residual functional capacity of less than sedentary, meaning you could not even do a simple sit-down job, is disabling. So you want the judge to conclude that your RFC is less than sedentary. Or if you're over 50, maybe less than light. So if you're over 55 is less than medium. So it can change, but if you're under 50, you've got to have a less than sedentary RFC, unless you meet a listing, in which case it's kind of assumed. All right, Allie says it took about a year for them to approve SSI. That's actually quick. Okay. Sherry says, had my phone hearing today. Good. I think it went well. The judge said something about being 50. The hypothetical, too, of having the cane and walker prevent me from the job. Yeah, that's a positive, because if you're 50 and they're looking at the grid rules, and you're limited to sedentary work, light work you can't do with a cane and walker. So, and many jobs you can't do with a cane and walker. So, yeah, I think that sounds pretty good. So it sounds like you'd be limited to sedentary work at best if you're over 50. And you've got something else that would eliminate transferability of skills like medication side effects or focus and concentration issues, then sounds like you've won. That sounds like a pretty good sign. Jeff Brown says, how long before I can reasonably apply if you stop working? Apply the next day, Jeff. You don't need to wait. No reason to wait at all. Just apply as soon as you stop working. And get it ready to go so that the day you stop working, you can press that button. You're ready. You know everything you need. Martini shot. I applied mid-September. Have reported retirement pension that begins December 1. I'm 60. Have 4 health conditions, one's incurable. How much longer to wait? I mean, you're 60. That helps a lot. The vision, one that's incurable, vision loss. And again, if you're talking about meeting a listing, it's basically got to be 2200 or worse in the better eye. Being over 60 makes it a lot easier. And I think this emergency message is really designed to get people like you approved more quickly. So ideally you get approved in 5 or 6 months, but Social Security, there's no guarantees. But I would say you more than a lot of people will have a better chance of getting approved early. All right, so RFC, that again stands for residual functional capacity. That is a legal term that reflects or defines your capacity for activity, for work activity, after taking into account, the medical issues and the functional limitations associated thereof. Sherry is 53. Being the 50, does that sound like a win? Yeah, I think that being 50, between 50 and 55 is kind of the the time period we're looking at. So, being between 50 and 55, if you're limited to sedentary work and you have no transferable skills to another job, you win. So I think it sounds pretty good to me. Violetta says, thank you. You are very welcome, Violetta. Let's see, come back as partially favorable. Yeah, I don't think that's the only reason it could come back as partially favorable would be if you were 48 or 49 at your onset, then you turn 50. A judge could say, I'm going to find you disabled as of your 50th birthday, but not before then. That would be a partially favorable. And you have to make a decision whether you can live with that or not. Many times people just say, I'm going to go ahead and live with that, assuming there's no date last insured problem. Nikita was denied in November of 23 because of lack of medical records. The PCP, because she didn't release her records in time. If I'm approved in the future, will the SSA issue back pay? If you're denied in 2023 and you did not appeal, then the earliest onset that you can use is the day after the unfavorable decision. Everything up until the day of the decision, the date on the unfavorable decision is what is called res judicata, or a thing decided. So you cannot say, I became disabled in 2022. They're not going to reconsider a decision that's already been found that you are not disabled through November of 2023. So even if it was because of if you didn't appeal, even if it's lack of medical records. So when you reapply, they're going to be focused on the time period from November, whatever the date in November is in 23 through the present. You want to make sure that your date last insured is, after that date. If your date last insured for Title II disability was in October of 2023, you got a big problem because you won't be insured for Title II disability. You could pursue SSI, but not disability. So there's some things you want to look at. The decision will tell you your date last insured. But if you're approved in the future, and of course, if you go back to work, then that'll push that date less insured forward as well. But if you're approved in the future, you will not be able to go back prior to the date of the unfavorable decision. Willie Vett says, hit the like button. Thank you, Willie. I really appreciate that. That is something that would be much appreciated. And I put this down here. If you find this useful, please do leave me a review. Those are always very, very helpful. And the like button and subscribe. And as No Sky mentioned, if you click the like button and the little bell, you'll get notified every time I schedule one of these. And again, it's every Wednesday with rare exception at 8:30 p.m. Eastern. So tell your friends. SA has been going through PT for his back for about a week. Hopefully that goes well. And look, I hope that everybody who's starting the disability process, you can find treatment that'll make you better. I mean, disability is not something that is an easy road to get. It's not necessarily a good thing. You're limiting your socialization. So your health is a lot more important than disability, quite frankly. If I could snap my fingers and make all my clients healthy again, I would do that. That's really a better way to go. Presley Watkins says, I had a stroke in 23 and got denied after medical review. Lost your ability to speak and have nerve damage in the right hand, still can use it. I choke and lose my breath, exhausted. Were you denied at a hearing, or were you denied at the administrative level? That sounds crazy to me. I would think that if you have not if you're within the 60 days, appeal that. If you're beyond that, you might be able to even reopen. Sometimes that's another point I would make. Let's say that you got a denial notice in mid-November, November 15th of 24, and you didn't appeal it in time by middle of January. We're now February 5th. You can, in many cases, I could file a motion to allow for a late filing of an appeal and keep that original case alive. Now, if it's a month or two, they usually are okay with it. You get beyond 2 or 3 months, it starts to become a little more problematic, but it does happen. So I would say, if you were denied, don't give up. When were you denied? If it's really recently, if you're within the 60 days, appeal it. If it's shortly past the 60 days, you could still appeal it and ask for good cause to extend the time for appeal, or you can start over again. But if you lost your ability to speak, nerve damage in your right hand, especially if it's your dominant hand, and you choke and lose your breath, and you're exhausted, fatigue is a problem. I mean, I can't, the question is, could you be a reliable worker 8 hours a day, 5 days a week? I mean, I think you got a pretty good argument, especially if your doctor will support you. That would be a real problem with all those symptoms. Lady JJ, self-care and more. She is 48, been denied 3 times, reconsideration, other hearings, since already had my cervical discectomy, got an injection, will get a cervical fusion next, quit my job. Will you win? Again, I think 48 is one of the issues here. I think the fact that you've been denied at prior hearings, that works against you to some degree. My gut tells me that if you could wait till 50, you're a different age category, you have a cervical discectomy, you could argue that lifting more than 10 pounds is a real problem. Now you meet the grid rules. So not impossible to win earlier, but my gut tells me if you could wait till 50, if you could hang on till 50, your case is going to be much better based on the limited information I have in front of me. Kimmy says, oh, thank you very much, Kimmy. I really appreciate that. Much, much appreciated. This is how to get a case evaluation. JMEC, sent an email to the Senate and Congress. Good for you. They got back to me, looked into my claim to file a release. Yeah, I think it is. I mean, they'll do a congressional inquiry, and that will speed things along. That is the one thing that will speed things along. So good for you. That's a good thing to do. Wicked. 50-year-old just had quadruple bypass graft, I think you mean. December 15th, the hospital submitted application with the coronary artery bypass graft was happening. 2 questions. Let's see what the question is. Question 1, can files be expedited that you've seen? Yes, they can, and that's where that new emergency message comes into play. The main metric that deals with the heart strength is ejection fraction. That is the amount of blood your heart pushes out as a percentage of blood moving through your beat. And if your ejection fraction is low, 20, 30%, 25%, then that's a really makes your case that much stronger. I don't see the other question here anyplace, but I would say this, that if you've had a quadruple bypass, by definition, they're going to assume you're going to be out for 6 months because that takes a while to recover from. If you have any complications or other things that get you to a year, you're at least going to be at a closed period. Now, a heart transplant, I think they give you a year, but quadruple bypass may be 6 months. So it's not a slam dunk, but if there's any complications, if the graft was not 100% successful, then I think you have a pretty good argument. And maybe you have an argument for a period of time of up to a year prior to the graft, because obviously, that doesn't just happen overnight. So I would say that would be something to look at here. Wow, somebody left me a $50 tip. That was way above and beyond. I really cannot tell you. Corlil Katana, thank you for the staff. Well, great, thank you. I really appreciate that. I will let them all know, and that is great. Thank you very, very much, and good night to you. Really, really appreciate it. That was very, very generous. Okay, so I think that Wicked, the real question here is if the graft was successful, and now you're, after recovery, you're able to do a lot of things. You can walk, you can, you have your energy back. Then, did you make it a year where you were unable to really function? And that's seems to be the big issue, or were there complications that made it more difficult? Does Social Security drug test you? No, they do not. West Ender says, I've been an SSDI recipient for 10 years after a 25-year career, professional career, only 1 CDR. I'm 53 years old, not medically been cleared to work, resume full-time. Should I expect another CDR, especially given my disability psychiatric? Probably not. I've got a couple of cases now with people with, treatment-resistant depression who are in their 50s, and they're coded. There's no review. They're not going to review them. I think it's very, very unlikely. Very unlikely. So no guarantees, I would tell you, but I think it's just very unlikely. All right, here. Okay, SA has been, just went to PT, I think, just for a little over a week. Employer demands my light duty restrictions be renewed every month. I get the form to my physical therapist to give her the spine doctor. Again, light duty is not disabling, so you're going to need more of that in the Social Security disability world. But yeah, your physical therapist and your doctor are going to have to continuously certify your restrictions. Certainly for an employer for you to keep your job, it wouldn't necessarily be something for Social Security. And go back to Wick's question. And they expedited again. This is where a congressional inquiry would come into play. I would write your congressperson. Just had a quadruple bypass. I'm suffering. This case should be approved. Please do something, and hopefully they will. The spine doctor not seen us under December. Therapist. It just depends. Some physical therapists are comfortable doing an evaluation as far as your light duty status. Others will require doctors to do it. Just depends. Right, Allie is 25 going to 26 with the SSI case. So again, they're going to look at you closely because they're trying to cut back on people in their 20s. No question about it. Laura is a 60-year-old with thoracic herniation, cervical lumbar stenosis, severe chronic pain. Do I have a good chance? Yes, you do. That would be a profile that says to me, you've got a good shot. Because the herniation and the stenosis are objective types of evidence. That's not an opinion, it's objective. And your complaints of weakness, pain, numbness, difficulty walking, holding, carrying are going to be consistent with that type of objective testing. So I think that would be a case. That looks like a pretty good case. I'd look at that real closely. Looks like a good one. Lucy, 50-year-olds. I was diagnosed with breast cancer. Went back for chemo. Let's see. We got more from Lucy. I don't know if I've got the rest of her. I don't see anything more than that. But I'm sorry you were diagnosed with breast cancer. And again, many times, as you well know, the chemo, the radiation can be as disabling, can be the true disabling part of this. Plus, there's a psychological element to it. But if you're nauseous all the time, if you're weak, if you're fatigued because of the treatment, even if and hopefully the cancer is not metastasized, then that's going to be disabling because you're just not going to be able to function reliably 8 hours a day, 5 days a week. Jenny says no Christina from California. So far, no. I made that point earlier. Is Christina is almost always here, and I'm kind of it's not the same without her. So Christina, if you're watching this on a replay, we missed you. Hope to see you back soon. But she's always saying, please give it a like and thumbs up and subscribe. And so Jenny, I'm going to deputize you as Christina's assistant to tell everybody to like and leave a positive review and to click the button to what is it called, the little bell to get notified. So you are now taking Christina's position. So I hope you can handle it. And hopefully we'll see Christina next week. Mrs. K. Good evening, everyone. Hello, Mr. G. Can I call you tomorrow? If so, what's the best time? Fill out the form submitted. Need some wisdom on what to do. Just email me. Just send me go back to the form. Tomorrow I'm doing a lot of hearing prep, so I'm kind of in and out. And I kind of have to block out part of my day. So just tell me what you specifically want. And if it's something that I can do by email, I'll do it by email. If it's something that needs a call, I'll either call you or have somebody call you. But I just, I get a lot of phone calls every day. People, and they want to ask me what's the status of my case, things like that. So I really try to work it within our system. But if you email me, go to ssdanswers123@gmail, say, I'm Mrs. K. I was on your live stream last night. Here's what I need. Then we'll go from there. Sarah D. Okay, Sarah's the person who's 39. We were going back up to Sarah, has a lot of stuff going on, the anemia and so forth. So yeah, so being 39, the diabetes is out of control. Again, this is one of these situations where even though you're 39, you might be one of the people that can win in your 30s because your condition is so severe. So, again, more of an uphill battle, no question, no question. So we'll just have to, I would just tell you that you've got a good case medically, but your age is the big issue. All right, Ms. K, again, you let me know who you are, and I'll respond to you one way or the other. I promise you that. Okay. Independent music group. Okay. IMG, I'm 57, low back issues. Again, it depends on how bad it is. You have objective testing, you have MRIs. What do you got? And how severe is it? How old? You're 57, that helps you. I think the real question is, what do the MRIs show? What do the objective tests show? Okay, GC, you denied the ALJ and the Appeals Council when you refile the DDS and new claim reset your hard work RFC that's stacking the deck. Okay, I'm not sure if I completely agree with that. I think that if you look at your ALJ denial, it'll say the judge found you limited to this residual functional capacity. If it's light, okay, there is case law that says that the DDS has to start with light. They can't give you a more expansive RFC unless there's really compelling evidence to do so. So I think they'd be limited to starting with that, reduced RFC. Now, if the judge said you medium RFC or no limits at all physically, then different story. But if you have, if you're, let's say, 48 and you're limited to a light RFC, I don't think if you reapply that the DDS can say, oh, you've got a medium RFC. I think that, they're limited to at least what the hearing judge did at the time of the hearing. Madison is 90% VA rated for hearing loss, tinnitus, foot pain, mental health. Can I file? First of all, I would say, we don't know how old you are, Madison, but 90% VA, that's not binding on Social Security. That will also not get you to the front of the line. Got to be 100%. Let's look at the issues here. And again, keeping in mind that the reason why somebody would qualify for disability is they would not be able to be reliable at a job. Hearing loss will eliminate some jobs in tinnitus, some jobs without good hearing, but there are jobs you could do with, limited to no hearing, packing jobs, maybe a marker job where hearing is, you don't need to be able to hear very well to do those jobs. Bilateral foot pain, is it temporary? Is it permanent? What is the basis of it? Is it something that can be corrected with a orthotic or something like that? What do the MRIs or x-rays show? Are there broken bones? What's the cause of it? If you're over 50, that may limit your standing and walking so that maybe you hit the grids, but it depends on how old you are. But bilateral foot pain, you've got to have how severe is it? What's the cause of it? And mental health, again, you've got to win on mental health, you've got to have, a level of severity that would put you in, a psych hospital or suicide attempts or multiple medication trials. They're not successful with your doctors. So again, you don't win on the diagnosis, but I think it's going to be, all of this is going to turn on your age and the evidence. Martini shot has vasculitis, giant cell arthritis, carpal tunnel, chronic plantar fasciitis, fibromuscular dysplasia. It's 60. Yeah, these are all things I think that make your case pretty strong. I think all those things, at a minimum are going to limit you to light work. And you got severe pain, then you meet the grids. So I think you've got a pretty good argument for the grids. All right, Bluesy, I think, is the person with breast cancer, 50 years old. Chemo radiation, hormonal injections, a lot of side effects. Yeah, side effects could be enough to disable you. Now, you had breast cancer 5 years ago. So the question is, did you return to work? Have, the side effects now become more severe? Have they manifested themselves more recently? Are you on new drugs now? If you went back to work after the original breast cancer diagnosis and treatment, why were you able to do it then but not now? That's the question a judge would ask. Ruth Rosario, our chiropractors are authorized medical evidence experts, not for Social Security. They're considered alternative medical providers, and they're given no weight in a disability case. Fong Trong, according to my adjudicator, DDS medical expert requests a physical evaluation to determine if I'm sedentary or light. I quit my HVAC job to physical and mental impairments. 56-year-old male. Yeah, I mean, I think that even if you could do light work, you grid out. So really, they're going to have to find you could do medium work, assuming you don't have, and there's not going to be any transferability skills to a sedentary job as an HVAC contractor. So I think you got a pretty good argument under the grids. Look at 202.06 rather, grid 202.06. Go to gridrules.net 202.06. I think you got a winning case based on that, what you're telling me here. If money, gifts for an SSI case are gifts from friends and families, that income, no, but it could be an asset. So it's an asset that could be a problem for you. You can have up to $1,000 of assets or cash and still qualify for SSI. I don't think that gifts on a monthly basis would count as income. I don't know. That's a good question. But I guess it would be monthly receipts. So I still stand by, if you had some sort of a written agreement to repay, that money was considered to be a loan, I think that might work in your favor. But, again, I would reach out to Greg Brinkley, greg@gregbrinkley.org. He would be a better person than me to answer questions about SSI income and resource. I just don't deal with it enough to really say. Independent Music Group is 57, lower back issue, sciatica, leg weakness, bound to a wheelchair for 20 months, pending reconsideration. Why is it taking so long, John? I'm not sure if you're John or you're asking me. It's just, I can't give you an answer to that. They're just understaffed. And this is a case where I would contact your elected representative. What I do in those cases is I send a note to the adjudicator, like, here's the evidence. What more do you need? What do you need? I mean, this is especially if there's MRI evidence that explains the sciatica. What more do you need? I mean, but I think you have to be a squeaky wheel here. Ruth says, what happens if you submit your function report? After you submit your function report to the DDS, they look at it. They're supposed to have a medical expert or medical source person look at it again under this emergency rule. They may not have to anymore, but this is part of the puzzle to determine your functional capacity. And so what the adjudicator is going to be looking at, and the question they're going to be asking is, are the functional issues you've identified on that report consistent with what the medical evidence shows? And if they say it is, and the functional report documents extreme loss of function, you win. Most of the time they find that, that the function report, the functional limitations you claim are not entirely consistent with the medical evidence, and they turn you down. Then you get in front of a judge who hopefully would reach the opposite conclusion. I think we already talked about that one here, about the physical therapist versus doctor. And again, it just depends on the provider. Lily says, thank you for helping to answer the judge's question. I'm in treasure. Well, thank you very much, Lily. I'm glad that was helpful. And again, I think, the questions that the judges ask, I'd say 60% of them are the same thing over and over. So if they're coming and you're going to be asked about, your past work, you're going to be asked about your physical capacity, sit, stand, walk, lift, carry, kneel, crouch, crawl, stoop, climb ladders, ropes, scaffolds, things like that. You can be prepared for it. If it's mental, you're going to be asked about focus, concentration, emotional stability, be able to maintain, to keep a schedule, to be on task. So you just want to practice and be very specific. It just really comes down to being very specific about everything. Just eliminate from your vocabulary any not very much or not very far. I think if you do that, things will go a long, long way for you. Ali Tovar says, thank you. You're welcome, Ali. I hope things work out for you. Mike Bolton, have a hearing in April. Hard labor my whole life. Welder mechanic, mines to forklift. Can't do any more job pain, back and neck. 58, Grid rule 202.06, that's what I would think. I mean, I think physical labor your whole life. You're 56. If there's evidence of that you're limited to, you can't, even if you could do light work is standing and walking 6 hours a day, lifting 10 pounds frequently, 20 pounds on occasion, you're still disabled. So they have to show you can do medium work, which is lifting 50 pounds on occasion, 20 pounds frequently. With all this stuff, I don't think you can. So I think you got a really strong grid rule argument. Sure, you can email me. Look, the best way to do it is go to ssa.gov or see that. If you see that link that's crawling below, that's the best way to reach out to me. Okay. No problem. So I'm coming right down. I'm Jonathan Ginsberg. That's my name if you're looking for me. But again, if you just go to SSD Answers, you can read more about me. Let me take this off, I think, and you'll see. I think I've got it there. Oops. Okay, so there's my name if you want to know how to spell it properly. Okay. Robert Leverso. Good evening. Wanted to say hello. Hey, Robert, how are you doing? Been getting my MRIs updated the last couple of months. Had a cervical spine, both knees, nerve test coming up. And also, Robert, you're leaving me hanging. All right. I don't know what the rest of your question is, so I'll wait for that. But I know when you reached out to me, I think there was a workers' comp element there. Because you're 59 and workers' comp, that was the issue. But yeah, I think, setting aside the workers' comp, am I right? Am I right on that? Just looking you up. Oh, okay. When you originally contacted your workers' comp, now, because I remember I saw your case come through my office. I'm like, you hired me. It's like, why am I seeing workers' comp? That was back in 2023. Okay, makes sense now. Okay, so yeah, getting your MRIs updated. Yeah, because I knew I processed some paperwork for you. Like, why am I losing my mind here? But just certainly possible. Cervical spine. Yeah, I think you've got, a bunch of stuff going on. I'm not going to go into details of your case, obviously in public, but yeah, we've got enough here. We're going to win. I'm pretty comfortable we're going to win. But yeah, you're doing everything right as far as getting your MRIs up to date. Dolly Parham. What does it mean if you get a work history report and the adult function report from the adjudicator, but don't receive the disability report and they send it for? Don't they send out certain forms? They'll send out a bunch of forms. I wouldn't get too worried if they don't send you one form, and they send you another one. They're going to send you what they want to send you. Just answer whatever they send you, fill them out. But I wouldn't get too bent out of shape if they don't send you this form or that form. Every adjudicator does it a little differently, but I don't think you can read anything into it. Okay, so Angie has an answer for Ali Tovar. Again, I'm going to defer. I don't know. I do not wish to wade into this because I just don't know. Chantet, you're 49, 5 times brain surgery, right eye completely blind, left eye central vision only, frequent urination, weight restriction, 10 pound, 27 years, waiting reconsideration, 6 months. I think you have a good case, number one. I think number two is, even though you're 49, I think you've got enough here to win. And I think that reconsideration, is going to be 8 to 10, 12 months. So you're sort of at the point now where you should be getting close to getting a decision. So I would think you'll get a decision next 2 or 3 months, but you've got a winning case, I believe. Giselle got fibromyalgia, arthritis, depression. Fibromyalgia is a tough one, I will tell you. It's really, really, now you have brain fog and you've got cog fog, okay? And use a cane, that certainly helps. But again, they just look at everything as all the factors together, your age, the nature of your impairments, are there objective tests? That's what they're going to look at. So Angie, I think you're right. I think that's exactly right, Angie, is what she's referring to Ali Tovar. Sheila is 64 in Recon, chronic vein insufficiency, um, bilateral iliac vein clotting disorder, just had toilet replacement. Yeah, the grid rule should have been, I mean, I think not only do you meet the grid rule, but there's um, a rule in the POMS, which basically says that at 60, they have to prove you can go back to your past work, basically. So yeah, you should be approved, you know, I would think under the grids at Recon. You know, now the hip replacement is certainly physical, and I think the other stuff would create a physical limitation that would implicate the grid rules. So yeah, I don't know why they wouldn't. Robert, who's been one of my clients, yeah, we'll see. I mean, I think that, you know, we're just going to keep giving him more stuff, more information. We're just going to keep pushing, get you approved, try to get you approved early. That's the goal. Sherry, thank you. Let us know. Yes, let us know, Sherry, please. Giselle, so you're the second Giselle we've got today? Yes, we had another Giselle, I don't know. You don't see too many Giselles, I think. But hello, how are you doing, Giselle number 2? Okay, Angie apparently used to work at Social Security a long time ago, 10 years as a claims rep, and gone 15 years, so I'm sure there will be changes, but get a rep. And yeah, okay, so Angie's got some knowledge about what's going on. She used to work there. That's very helpful. Okay, Carissa, I haven't worked since. We don't know when. Incontinence consideration, yeah, that's, yeah, I mean, I think that's also a really, really important factor. That's going to disable you from a lot of jobs. Okay, so here's Carissa. Have not worked since March of 23, applied for SSDI. I'm still waiting on the appeal process. Have axonal demyelinating polyneuropathy, tarsal tunnel, cervical lumbar radiculopathy. How old are you, Carissa? That's the question. I think that's significant medical issues. Obviously, if you're over 50, it's going to make it stronger, but I think it sounds still pretty good. You've got a lot of significant things going on that are not, unfortunately, not going to spontaneously get better. Presley says, thank you. Welcome, Presley. I appreciate that very much. Have you seen challenges with long COVID symptoms? You know, I'm starting to get those cases now because obviously they kind of came out in 2020. You know, I'm starting to see more of them. You know, I think that the main thing in long COVID is the respiratory issues. That seems to be what moves the meter. Do you have chronic respiratory issues? Some chronic brain fog seem to be some of the issues I'm seeing as well. A lot of my COVID clients have other things going on too. I'm getting mostly favorables on them though. I've got documented long COVID. I'm winning most of those. So I think that's those are pretty, you know, I think they're pretty good cases if it's well documented. All right, so Carissa, we've got significant medical issues, spinal stenosis. She's 47, uses a walker. You know, again, I think if you were 57, you win easily. 47, I think you've got enough to win based on what you're telling me. I think you've probably got enough. You're one of those cases of a person under 50 who's got enough with most judges. Not to say there's some judges who would not approve you, but I think most judges likely would. Okay, so this is the way I talked about this before. Corlil, Katana, much appreciated, as I'm sure the staff will be much appreciated as well. Asthma, shortness of breath. This helps, absolutely, because again, it's going to eliminate jobs being in dusty environments or, you know, hot extremes of heat or cold, things like that. EOC, maybe AOD you're talking about. I'm not sure what EOC is. 123.23 approval date was 130.25 SSD. How many months of benefit? So if your onset date is 123 of 23, I don't know when you applied. Let's assume you applied within a year of your onset date. We'll just use that. So let's say you applied in December of 23. They don't pay the first 5 months, so they would not pay you for the remainder of January. It's 5 full months. They won't pay you for February, March, April, May, June. Earliest you're going to get paid is July of 2023, assuming you applied within a year or at least maybe 18 months of that date, because you can use up your 5-month waiting period before you're eligible for payment even. So I'm guessing July of 23 would be the first payment date. Denied twice, hard maintenance, April hearing, 58, do you need a lawyer? I'm not a fan, Mike, of going to a hearing without a lawyer. You've got a winning case. The risk you run is that, because and there's no reason you should, you're not going to know how the process works. It's going to take the judge longer to go through the file and to, read all the disclaimers and all that kind of stuff. There's some judges who get upset by that. Some judges like to throw their weight around. I would be surprised if any reasonable judge would turn you down given the facts you've got there. So do you need a lawyer? No. Do I think it's wise to go to a hearing before a judge without a lawyer? No. You're going to have to make that call. I think you probably have enough. Now, the other thing you want to keep in mind too is, once you request a hearing, nobody's developing the medical record anymore. So you got to make sure that, all the medical evidence is updated, is within maybe 3 or 4 months from the time of your hearing. So let's say through, maybe February of this year, you've got to submit it. If you go in there with an incomplete record, you may have a judge who's not real happy with you. If you have a judge who asks a crazy question of the vocational witness, you're going to be prepared to cross-examine. So I think you've got a winning case. Most reasonable judges would approve it, even if you don't have a lawyer, but you're taking somewhat of a risk. How much of a risk, that's up to you. But I think it's overall a winning case. And I know I'm being lawyer-like and not giving you a definitive answer, but to tell somebody to go in front of a judge without a lawyer in a hearing that's going to last 45 minutes, I don't think I'm not telling you right if I tell you that's a good idea. There's an old saying in the law business, he who represents himself has a fool for a lawyer. On the other hand, 25% of past due benefits is a lot of money. So you got to make a call on that. Salim says, I have facial paralysis, speech impairment with consciousness syndrome, 55. Not sure what consciousness syndrome is. I would say, Salim, that facial paralysis, speech impairment is going to eliminate jobs that require verbal communication, which is not an insignificant number of jobs, but there are plenty of jobs out there that do not require much speech. Consciousness syndrome, I'm not sure what that is. So if it means you lose consciousness, at irregular times, that's going to be a bigger issue. It doesn't sound like these problems are physical in nature, so the grid rules are not going to be implicated. So you're going to have to prove that the combined effect that, you can eliminate jobs that require verbal communication, and whatever this consciousness syndrome, that is going to prevent you from doing anything else. I just don't know what that is. I've never heard of it. Willie Van, well, thank you, Willie. And again, that's something, I hate to tell somebody, because look, 25% is a lot of money. I realize that, but 25% of zero is also still zero. So, or 100% of zero is still zero. So that's just a judgment call. KJ, I got my LJ decision a week. No such luck with the award letter and back pay. I'm not sure what you mean. If you just mean there was no back pay or you lost, I don't know. Laura, thank you. Well, I appreciate it, Laura. Thank you for tuning in. Leah, okay. My approval of the mails from your office, a graduate of 6 months from filing. Yeah, that's right. We won early. And that's, as I said before, I like to win early. Love to win early. And if we can win early, that's great. I don't care if my fee is $100. We want to win early. And, when I do my applications, I'll put in there, I just did one today. I got a case of a guy who I think is compassionate allowance. Please review this case under listing, whatever it was. Please evaluate this case under compassionate allowance. Please evaluate the case under the grid rule. Try to win early. And Leah's an example of one of my clients. We went early. And that's because, that's what you want to do. You want to win them early. There's plenty of cases out there. And, I have a happy client. You know, that's really what I want. Okay. You're welcome, West Ender. My pleasure. Okay. 59 with lumbar stenosis, x-rays tomorrow, evaluation tomorrow. You should be fine. Again, how bad is the stenosis? 59. You need to basically show that you cannot do light work, and the grids, I think, would apply. Especially if you've got really supportive MRIs, you should be able to hopefully do that. Tara says, like and subscribe. Absolutely. Joe Blow, Buy is me. Is it Joe Blowby or Joe Blow? Sure. I'm on SSI and started working at the table as a construction helper. How would I go out reporting my wages? Don't think he does W-2s. Might give me a third-party contractor form. Yeah, I mean, I think that, you know, the 1099, the 1099 is going to be reported to the IRS, which will report it to Social Security. If you're over SGA, first of all, you've got non-trial work period months. So if you've, you know, if it's less than 9 months, you're not, no problem. But once you get beyond that, if you're over SGA, you could find yourself in an overpay situation, which is not a good place to be. So yeah, you got to be careful about that. You want to really take a close look at that. Jenny Joe. So you are taking it for Christina. Absolutely. Like, subscribe, and leave a review. Let me thank you, Jenny. Appreciate it. I have you as Jennifer is what I call you, but we'll call you Jenny Joe here. All right. And here's where you can leave a review, but thank you very, very much, Jenny. And okay. Go Joe. I got a thank you and a thumbs up. Christina, you are back. Everybody's wondering where you've been. They're like, where's Christina? We had people asking. So, and I deputized Jenny Joe to take your job to ask people to hit the like, subscribe, and leave a review. So, you know, so I got both of you doing it, which is cool. But good to see you, Christina. Hope things are going well for you. Okay. Brett. Sure, Brett. I appreciate you tuning in. I really do. I enjoy doing this. It's a lot of fun. I've had some really met some interesting people. It's been great. Just filed my appeal, reconsideration, I think, after initial denial. 61 with Meniere's disease, and doctors have a shot at Recon. Yeah, probably not. I think this is a case that's probably going to go to a hearing. I don't think you're going to win Meniere's case at Recon. I just think they're looking for things that are really objective, and Recon is a very low approval rate. So I hate to tell you, Vincent, but probably not. Christina's got her own set of fans. Yes. There we go. Okay. Jenny has been deputized as Christina's assistant. Martin says, thank you. You're welcome, Martin. Mrs. K, you're welcome. TBI survivor says, esoteric fitness, need to file, keep my together just to file. Yeah, that can be a problem. I mean, I know sometimes, you know, TBI traumatic brain injury can make it really hard to focus and concentrate, but to win, you're going to need some documentation. But, you know, the fact that you had trouble getting it together to file is evidence, but not, pardon me, it's not enough to win your case, but it's certainly evidence there. Okay, so I don't want to leave that out. That's how to get a case evaluation. So No Sky is going to be happy if I make sure to put that on there. I'll take the review thing off. So again, if you can leave me a review, please do so. There's the comment here. Okay, GC Styles. It was a reduced range of light work than you mean heavy work, I think, at denial. I think you can appeal that. You can appeal that. What's No Sky? What is incredible? Something is incredible. All right, Laura, this channel is very helpful. You have questions? Thank you again. My pleasure, Laura. You are very welcome. Wouldn't the government save billions of dollars by eliminating those worthless agencies like HUD and food stamps and Medicaid, just paying people through an SSDI maybe $4,000 to $5,000 a month? Interesting thought. You know, Could be. That's an interesting question. It kind of reminds me of something that Charles said in his blog was, that there's been some talk about let's eliminate the fraud in Social Security, save all this money. The problem is the cost of investigating the relatively small amount of fraud is more than what you would save by eliminating the fraud, if that makes any sense. In other words, if let's say that the fraud in Social Security, let's just pick a number, $50 million, but that's probably too high, but let's just use that number, $50 million, which is a hell of a lot of money. But it would cost $55 million to hire the people, do the investigations, to root out that fraud. What's the point? Not that you want to condone fraud, but if it costs more to root it out than you're saving, what's the point? I think that's what T. Cash is getting at, is if you have, all these agencies that are servicing people that are disabled, why not just pay them more in the disability side of it as opposed to having all these other ways to give out money? I think probably the answer is that not everybody on using HUD or food stamps or Medicaid are also on disability. Some are, some are not. So, and I think the other thing is the way they figure out how much you get is based on what you pay in. So if they give you more, than you've paid in, then that becomes a problem when it comes to retirement Social Security. So I think the concept is an interesting one, but I don't think practically there's any way for that to happen. Okay, essay. Okay, that's possible. I'm seeing retracted messaging. Okay. Again, I think you can appeal that. I think you can appeal it if they're giving you an RFC that is less restricted than what the judge gave you at your hearing. Okay. No Sky is happy to see Christina here because every week we got Christina, so we almost thought we didn't have you this week. Okay, Brett is 100% disabled, retired vet. Thank you for your service, Brett. Really, that's something that we don't tell our veterans enough, how much we appreciate what they've done. And you've obviously, had some issues that arose from your service. 100% for deafness, 70 for depression, 40 for diabetic neuropathy, 58 denied wants to be rated 100%. Now, if you're asking me a VA question, I'm not the right person to ask that. But if it's in the Social Security, all I would tell you is that the VA determination is not binding on Social Security. So that's point one. And the other question is, are these other issues? Deafness will eliminate some jobs, no question about it. And there is a listing for deafness, but it's got to be almost complete. And depression, again, it's got to be a very, very high, very significant level of depression. Diabetic neuropathy, is it going to eliminate what your use of your hands and your feet? Would it be enough to eliminate light work? And that's really the question, I think, is the way I would look at it. Is it going to be enough to get you on the grids at 202.06? But 58, that's going to make it a little bit easier. Madison, 62 with years of evidence, military follow VA. Again, VA is fine as far as supporting a Social Security case, but it's not binding on Social Security, and VA records are a lot to kind of plow through. So you need objective testing is really the big thing here. Sistania. I have a hearing coming up next week on the 11th. Gitelman syndrome, multiple chronic issues. Well, let's take a look and see that doesn't ring a bell to me. It does ring a bell, but I don't remember what it is. Gitelman syndrome is a rare inherited kidney disorder that causes an imbalance of electrolytes, minerals, particularly potassium. It's a genetic mutation, and it can result in muscle cramps and weakness, fatigue, low blood pressure, muscle contractions, bone pain. I think it's going to really depend on the severity of the symptoms and how old you are. The diagnosis doesn't win you a case. I don't think that it's a rare disease. I don't believe it is in the compassionate allowance category. It's a genetic condition that looks like it can be mild to moderate to severe. So I think if you have a severe case, the symptoms are well documented, they are work preclusive, and that can be documented, then you've got a good argument. But if you're 35, much more difficult than if you're 55. So I think those factors come into play. How severe, how old are you, and what are the work preclusive elements of the diagnosis? Mark T, I got approved, but how long does it take for back pay? I'm seeing money, because I typically get paid when my clients get paid, anywhere from 2 weeks to 6 weeks after a favorable decision. That's what I'm seeing. Tony Snell asks, if you have back pain with nerve pain down your leg and now your knee is worse because of this, would that be a better case? Absolutely, because now you have not only nerve pain, but now you have problems with your knees. So that's going to make it more difficult. For example, nerve pain might limit your standing and walking. The knee pain might make sitting more difficult. The pain might be increased at times. So you may have two different types of pain, and one or both may be enough to make it hard to focus and concentrate. So yes, that would make your case stronger. Lulu says, if you have all medical reports and support from your doctor, however, if you don't fill up well your function report, what could happen? Innocent mistake I made. Haven't sent it yet. Lulu, I'm not sure if you're saying that you just didn't complete the function report properly. You can resubmit it if you like. Just type the form number into Google and you can just download it or type it in online and then resubmit it saying, please, this is a better representation of my function. I think the medical evidence is really more important anyway, but if you think you made a mistake on the form, then resubmit it. Is it easier to obtain? I think 55 is sort of the break point, 60. 62, I would say yes, in the extent that at 62, many people have already applied for early retirement. So the disability trust fund's only going to be obligated for the difference between early retirement and full retirement. But my experience has been that, 55 plus is a good break point. 60 can be a break point. I don't think 62 in particular, but I would say 55 is probably more important than 62 in my case, my situation, or my belief. That's my website there, if you want to take a look at that. Allie says, good night. Good night, Allie. Have a blessed night, and good night to you. Tanya says, I'm applying for SSI. I don't have a lawyer. I'm doing this myself. Really some advice on the situation. I think Tanya was the person with Gitelman syndrome. Like I said, I would really make a list of all the symptoms you've got. What does the medical evidence say in terms of the severity of it? And you want to be able to identify specifically how the symptoms you have would make it impossible for you to be reliable at a simple job. Sitting, standing, walking, 5 minutes this, 10 minutes that, be as specific as you can. Is it going to be esoteric? Is it going to be easier or harder, the same with the new president, to retain disability benefits, obtain or retain? I would say overall probably more difficult. Just to be straight, I think it's going to be more difficult. Okay, so Blue Z, I think, had breast cancer 5 years ago, now has hormone. So yes, you're basically telling me that the treatment you're getting now, you got it for 5 years, but now it's things are getting worse. So that kind of makes sense with the narrative of why you're able to apply now, especially if you're able to work up until then. Yeah, I think that is a factor. How many doctor's appointments you have in a month you have to attend. Pardon me. I took the dog for a 4-mile walk today, so I helped my wife unload a bunch of mulch. I don't know why she feels the need to buy mulch in the spring to put in our yard. We're hosting. A friend of ours has a daughter who's getting married, so my wife agreed to host like a wedding shower. So she decided to go to Home Depot today and get a bunch of mulch, 75 bags of mulch. So we had to unload it from the car. And these are like 50-pound bags, and what am I going to tell her? No, I can't do it. But yeah, it was not the most fun thing in the world to do. Then I took the dog for a 4-mile walk. That's why I'm yawning. So, in case you're wondering. But yeah, I think that the number of appointments you have in a month, I think is relevant, especially if you can prove that you have to go during office hours, that you would be taking off from work. Giselle, number 2, has MS as well. That again makes it, that MS, depending on how severe it is and how symptomatic you are, that can make the case that much stronger. Brandy says, I have 4 endoscopies done in 1 year. Oh, that sounds uncomfortable. They want me to do 1 a month. Wow. Haven't lost weight. 52, chronic GERD. Do I have a chance? Again, chronic GERD is uncomfortable. Is it uncomfortable enough to make you not able to focus and concentrate at work? Do you have episodes of nausea? Do you have to use the bathroom more frequently? Do you have times, let's say 3 or 4 times a week, where you're just so sick you can't do anything? It's coming down to your reliability, dependability to job. How does the really bad GERD impact that? That's the question I would have for you. Alan says, 100% disabled for Meniere's. After 2 strokes, depression, hearing loss, 61 was terminated on Friday because of performance, open heart surgery. Absolutely, Alan. You've got, I think you're 61. You got enough there to win, I think, based on what you're telling me. Again, I would want to look in the medical record, but based on what you're telling me, I think there's enough here to win, and really more so on the, the knee arthritis, on the strokes. I think all these things, they're objectively determinable, make your case pretty strong, I really think. Eunice says, thanks. Eunice, I've seen you here before. Thank you for coming back. I appreciate it. Sis Tanya is 46 years old, thrice in hands and knees on my medical record. 46 is not as helpful as 56. And again, I think with the Gitelman, it just depends on how severe it is and what the symptoms are. Madeline works with me as a legal assistant paralegal. Hello, Madeline. How are you doing? Hope you're doing well tonight. Madeline's in Oklahoma. Kevin says, I have early arthritis from working at Walmart. Well, I mean, if you'd worked at Target, would you still have was it Walmart, or is it from the hard work? Age 26, now 40. Judges are blind. That's why the woman with the blindfold can't see. Well, the idea of the woman with the blindfold on that, the picture you always see of, blind, justice is blind, it basically means that there's a scale there. So theoretically, the scales of justice should be focused on the evidence, not on personality or color or sex or whatever non-evidentiary factor might be. So, that's theoretically what justice is supposed to be. In the Social Security world, there is a very real concern that the trust fund is going to run out of money. A lot of pressure on judges to approve only people who are older. So that is the reality of it. It is not, justice is, it's funny. I've been practicing law for a long time, and people talk about justice. That's not the goal in law. I have to put it this way. It's really about our system is adversarial. And even though Social Security is not incredibly adversarial, it is to a degree. You got a judge representing the Social Security agency, and their goal is to not pay you. So it's not about justice or right or wrong. It's about you have enough evidence to win where they have no choice but to approve you. That's what this is all about. It's not about justice. Now, they shouldn't use irrelevant factors like your age or your age, I guess, is a relevant factor. They shouldn't, based on your color, your sexual preference, your sex. They shouldn't base it on things like that. They shouldn't base it on if you have a tattoo or if you smoke or whatever. But some judges are still going to do that. But justice should be based on the evidence. And unfortunately, age, I think, is a relevant factor because at this point it's not a protected category under the law. Therefore, the younger people that are younger, it's presumed that they're going to be healthier and able to recover more quickly. And there's an underlying pressure on the judges and disability adjudicators not to approve people under age 50. Ruth resorted to all cases. No, 35% of claims are approved at initial. The people that appeal that are denied, about another 15% are approved at recon. The rest go to a hearing. But statistically, I'd probably tell you, 80% of the cases go to a hearing. Joellen Lehman. Oh, I see. I'm seeing a picture of a guy with a beard. And I'm like, Joe Ellen. Um, that does not look like a Joe Ellen, but I see there's a woman there too, so that must be Joe Ellen. And we got about, I'm going to do about 5 more minutes here. We're already at 10:30. 44, diagnosed March of 23, stage 4 colorectal cancer. I'm sorry, on chemo, lots of side effects and appeals. Why would they not be able to help? It doesn't make any sense to me. Are you not insured for disability? I mean, why would you be denied? Something's not adding up. I mean, only thing I'm thinking is you don't have enough credits. If you don't have enough credits for disability and you're married and your spouse works and there's no SSI because of income and resources, that's the only reason somebody would not take your case. I can't imagine otherwise, because it's a win. But in terms of the medical part, so there must be a non-medical reason. I'm guessing is you're not insured, or you don't qualify for SSI either. All right, essay says, if surgery is recommended for severe right lateral stenosis and moderate formal stenosis, disc bulge, is it mandatory? Not mandatory to undergo surgery, no. But it does show a significant problem if you are being recommended for surgery. So I think that definitely helps your case. Like Mike Bolton says, you've hired a lawyer. Well, good. I hope you win. You should win. And I wish it had been me, but it's not. But I wish you the best. I hope let us know. I hope you do win, Mike. TE, if I won my compensability hearing, they cut benefits off. I'm still in the midst of, does that help my, I'm not sure if you're talking about workers' comp. I don't understand the question. Okay. Well, you know what, Mike? I mean, there's a lot of good lawyers out there. I hope you got a good one. That's okay. Okay. Not sure what compensability is. Don't know what that means. Thank you, Christina. Esoteric, I think, is a mental health case, the TBI, a lot of documentation. That will help. You're hiring. I'm an EDP. Mauricio. Mauricio, send me an email. SSDanswers123 at gmail.com. Send me an email. I'm doing a reconsideration here. You're doing a hearing at reconsideration, not, so you're basically going down to the DDS and doing it there. Okay. That's, thank you, Mr. Ginsberg. Appreciate this Q&A. Is how to determine onset date for conditions I've had my whole life. I'd say the day you stopped working, yeah, because it's presumed if you were able to work, then you are, at that point, you are not disabled if you're able to work. So when you stopped working, that would be a good onset date. Why does question 6 say in the form, page 6 of the disability report, ask for 5 years of work history before becoming unable to work with the SSA POMs, say 5-year look back? I just think that at a minimum, they're going to want to have the 5 years. And you're right, it may be that the 5 years from, maybe because it used to be 15 years, maybe you're looking at an old form, but 5 years is the look back. But it's really 5 years from the time the decision is, like a hearing would be 5 years. And so if the person started their application 3 years earlier, they're not going to go back 8 years. So it's going to be a 5-year look back. They just ask it for the form in case they approve you early. But that's what they're asking me. You may have meant to me 15 years, but it's not 5 years. Adjudication, just because in some case, Matthew, that some cases they're approved early, so they want to look back 5 years. They don't assume every case is going to take 2 years to be processed. So they ask for it, and then they won't consider anything 5 years going back from the date of the actual adjudication in terms of whether you have past relevant work. Okay. All right. So we're going to do just another couple of questions, and then I'm going to go for the evening. Just a crazy Jen. Well, I've got a crazy Jen working for me. Good evening. Want to pop in and thank you for all your videos. Oh, great. I feel waiting to know after your hearing. I hope you don't have a denial, but, you never know. You never know with the judges. That's the gist. We're getting totally deaf. I hear nothing. Neuropathy's bilateral. Yeah, you shouldn't be denied. That's a good case, and you have a low approval rate, judges. You're only 38. Yeah, it's going to be tough. It's going to be tough. 5-step sequential evaluation process. That's something that Social Security uses. it's what that you'll see in a decision. I personally don't worry about it too much. I mean, I'm not taking cases if somebody's working. That's not really an issue. Their impairments need to be severe. They shouldn't be able to do past work. It really comes down to, in most cases, 3 questions. Do you meet a listing? Do you meet a grid rule? Is your functional capacity reduce you to the point you can't do any kind of work at all? So the 5-step thing is it's the legal mumbo jumbo stuff, but at the end of the day, that's not what most cases turn on. I just look at what the end of the day what the cases really turn on. Again, Brett, I don't know why they would turn you down. I do not care, Mel, about legal malpractice in Pennsylvania. I'm sorry, I do not. That's okay. I don't mind the bifurcated comments. That's fine. I can usually follow them here. Okay. Got denied twice. Adjudication, Florida knee arthritis. Okay, see, Mercy, it sounds like you got a pretty good case based on all those things. I think the grids would apply. All right, Christina says, no, she's here. No one's taken her position. I don't know, Christina, you were late. So I don't know. Well, we got Jenny Jo, who's real interested in that. It's unpaid, but, a lot of prestige, All right, a couple more questions. SSDI since 2020, now 60, where the odds of a CDR very, very low. Okay, this will be the last one because it's 10:35 here, been 2 hours. Longtime listener, use your YouTube information to aid your case. 1, great. New administration, how will it affect SSDI benefits? We may see more CDRs. I think that's certainly very much a possibility. We don't know yet. We don't really know if they're going to focus on disability. I don't know what they're going to focus on. We have not seen anything definitive yet. Okay, and Ruth Rosario was very, very nice to give me $20. I appreciate that. Thank you, Ruth. And you're the one asked about the chiropractor, I believe. But thank you. I really very, very much appreciate that. And again, my son, the video editor, will very much appreciate the sandwich he's going to get out of this. So, Christina, we'll leave it at that. Do not forget to like the video. It really helps the channel. It does. Thank you, Christina. And thank you for coming. I know you came a little bit late today, but I appreciate it. Good to see you again. And I hope, again, those fires are not near Bakersfield, because I think there was some rain, if I'm not mistaken. So hopefully we're past the worst of all this. So anyway, well, all right. We're, I think, at the point now where I need to go. It's about 10. We're doing this for about 2 hours. We'll be back next Wednesday at 8:30 Eastern. Tell your friends, tell your colleagues. Send me questions ahead of time. I think Thomas did, which was very helpful. So happy to look at those. And I hope to see everybody here next week. So for now, take care of yourself and be good to each other. And we'll see you next week. Bye-bye.